Were you
And
supposed to be there?
She tried to say that I tried to grab her out the window. She's over 200 and some pounds. How could I try to grab her out the window?
Oh, I'm sure you could if you tried. I'm sure. People miraculously build strength when they want to. You have protective orders with 4 different people. You can't even keep your story straight. You don't even know which charge goes with what person. That's crazy. What about all the previous strangulations in your history? Did you commit those?
An armed standoff in New Haven ends with a domestic violence suspect arrested. Police say the man was accused of pulling out a gun and stealing his girlfriend's car. Officers eventually pulled over the car on County Road at around 7 this evening. The man refused to get out of the car until a SWAT team and negotiators arrived.
Fearing that there was a gun, not wanting a direct confrontation or a shootout, officers waited and gave commands for him to come out. He wouldn't come out for a while. He kept reaching down inside the car, so that's why other resources were called in.
The man's identity has not yet been released. He is expected to be charged for this morning's incident, as well as several warrants for domestic violence and failure to appear.
And within just 1 year of this incident, of this newsreel, of the SWAT team being called, he already is up for parole. We're going to jump in and listen to this parole hearing, and I'm going to tell you, maybe those of you who are new here, there is a twist in this hearing, so make sure you stick around until the end. With that, let's jump in.
How you doing? Good morning to you. I'm Jason Randolph.
Sir, please state your name and your inmate number for the record.
I'm Jason Randolph, 292375.
Thank you. This hearing is being conducted in consideration of the parole application for Mr. Jason Randolph, inmate number 292375. He is serving a sentence of 731 days, 4 years of special parole for a violation of probation, underlying strangulation in the first degree, a charge of strangulation in the third degree, unlawful restraint in the first degree, attempted burglary in the third degree, and a failure to in the first degree. As of today, records reflect a parole eligibility date of January 6, 2025. There is no victim input in this case. There is an offender accountability plan. It has been reviewed and shows the offender has not completed any of the recommended programs. Utilizing the statewide collaborative offender risk evaluation system, the offender's overall score on the SRT falls within the high range of risk for recidivism. Mr. Randolph, this is your opportunity to express why you believe you should be granted parole. You may begin.
I had started the domestic violence program. I'll be completed with that on the 1st of this upcoming month. I'll be completed with that. Other than that, I've been taking the class real seriously. I've been going to church. Like, I'm actually glad that I had got locked up this time because I was on a run before this, and I usually work and everything and handle for my kids, but I was on the run and everything. So I just took this time to handle everything I needed to handle legally and just to get a fresh start. I am a worker out there. I usually do work. I have 6 children. My daughter, she just turned 20, July 14th. She go to Norfolk College. My son Trayvon, he's starting at Central College this year. He just graduated from high school. I'm starting in New Haven. And I got 3 more kids that's 13, a set of twins, and my youngest daughter is 13. And I just want to be there for them to help them go through it with school too. And I just feel like I'm really changed this time, and I took everything seriously, and I took advantage of everything too. So, and I just turned 41 July 7th, and I'm just different thinking now. I just needed to handle everything that I needed to handle legally to get a fresh start, and I feel like this right here is my fresh start to handle everything and be there for my kids.
All right, Mr. Randolph, thank you for your statement. So do you maintain that the victim lied in your instant offense and you didn't commit this offense?
Say that again.
Your explanation was that the victim lied to the police and you didn't do anything wrong in this offense. Is that still your version?
On which one are you talking about?
Oh, yeah, you're right. There's so many. Which one? Which one were you talking about when you denied committing it? Let's see. Hold, please.
because I violated my probation, but the whole time I was on probation, I maintained 2 jobs, clean urines, and I completed DV classes that I was supposed to do.
Well, you weren't reporting to probation. That's why they violated you.
Right.
Yeah, and that's because I had a warrant, and my probation officer said handle the warrant that I was supposed to handle. And
So
then
the probation officer told you not to report and then violated you for it?
No, she didn't say not to report. She said handle the warrant situation. And when I went to go handle it, that's when they I put a warrant out. I got arrested for that, and I came back out, and I didn't have to report to nobody when I came back out. But previously to that, that's when I got the warrant. I stayed in contact with the probation officer and told her and everything. I had clean urines.
So your probation officer lied too?
What you mean?
They violated you for not reporting. Were you reporting or not?
Yeah. I got violated for my probation for not reporting, but I told her everything before that. Previously to that I had a warrant and everything that I had to handle. And everything.
Okay,
She was
you still
aware.
have to report. What do you mean? Whether you have a warrant or not, you still have to report.
Well,
You think because you have a
aware.
warrant that excuses you from reporting to probation?
No, not at all. But the whole time I was on probation, I had clean urines. I had two jobs. I was reporting, but then I told her about the issue and everything. And before I got locked up, I just wanted to be there for my daughter's graduation. So
okay, so then you weren't reporting. You admit that you weren't
yeah,
reporting.
towards the end, I wasn't reporting. Yes, towards the end.
Okay, well then you violated your probation. I guess
Yes.
whatever else you were doing doesn't matter. How could you continue to do well if you're not reporting?
Yeah, I deserved to have my probation violated.
Okay.
I did break that. I apologize about
Right.
that.
The strangulation 3, did you commit that offense?
And what date was that?
Well, you strangled people on multiple times this time?
No. What it is that I've been violated of my probation, so I don't know if that's the old charges that's
It is
coming
not the
up.
old one. I'm not talking about the underlying case, but we can if you want to. Did you commit the underlying strangulation?
It was a verbal thing, and with the credit card. Is that the one you're talking about? I'm confused. Like,
She said you slapped her in the face. I'm sorry, the police person said you slapped her in the face and you choked her with your hands. She ran out and called the police. Yeah, you were arguing. The initials are LR. Don't say anybody's name on the record, please. Did you strangle her or not? If you can't remember, we have a problem here.
on that, the police report, if you look at the police report, they said that she had no marks to her neck or her face.
I don't care what the police report said. Did you do it or not? Because you were convicted of it.
No, I didn't strangle her.
Okay.
I had a plea deal.
All right,
That was part of the plea deal.
we'll move on to the April 22 strangulation. Did you commit that offense?
April 22. Can you say some of the case so I know which one that is?
How did you tell me what did you do wrong? Why are you incarcerated right now?
For the violation of my probation, I'm incarcerated right now.
Okay.
For the one that happened in Meriden, in Meriden court, yes, I did get in an argument with her, and yes, I did do that. The strangulation, third or whatever it was.
Yeah.
Yes.
What about the unlawful restraint? The initials are RS. Don't say anybody's name.
Yeah. Yes.
You threatened her and
yes, when we got in an argument, yes.
and forced your way into the house or tried to.
No, I didn't force my way into no house. I was staying there.
Did you push a window stand through the window? You what?
I was staying there at the house.
Were you supposed to be staying there?
And I gave her the credit card through the window.
Were you supposed to be there?
She tried to say that I tried to grab her out the window. She's over 200 and something pounds. How could I try to grab her out the window?
Oh, I'm sure you could if you tried. I'm sure. People miraculously build strength when they want to. You have protective orders with 4 different people. You can't even keep your story straight. You don't even know which charge goes with what person. That's crazy. What about all the previous strangulations in your history? Did you commit those?
Yes, I told you that with my baby mother.
So listen,
yes.
You're very lucky that we're not here for a manslaughter case. Actually, we wouldn't be here right now because you'd be doing a lot more time than 2 years in a day. When you put your hands around someone's neck, You have no idea, because I'm pretty sure you don't have a medical degree. You have no idea how much pressure it takes to kill somebody by doing that. And the chances become very high that you're going to kill somebody. What
Yeah,
makes you think you could put your hands around someone's throat?
No, it's not. It's definitely not right, and I definitely apologize for my actions. At that time, I was on alcohol and on drugs at those times, and
A lot of times. I mean, you've been abusing alcohol and drugs for a long time, and you didn't take a program to address that, did you?
Yeah, nah, that's how I've been. I asked the person that questioned me about the parole and everything. I told him that I would like to do the programs for that. And
who did your parole interview?
Shamroy. Shamroy, he did it, and he's supposed to have wrote down, because I told him that I would like to do drug classes, and I would also like to have a therapist to talk to, because during the last times of the incidents, that's when my father passed away, and I went back to drugs and everything, and I took everything real hard. So
wow,
it's no excuse for my actions, though. But
no, you're right about that.
I
mean, you've had plenty of opportunities. They tried to help you.
I was really in a dark place at that time.
I understand, but that's you have to learn to better deal with stressful situations in life. These things are going to happen. They happen to everybody in the world, right?
Yeah. And that's why I wanted to talk to a therapist.
You keep exhibiting the same criminal behavior over and over and over again. You're a high risk to reoffend. Come right back for the same stuff. And you're in the domestic violence program right now. You say you're going to finish it, but how many times have you taken it already?
This right here is my second time. I took it.
Nope.
I took it.
You don't even remember.
When I came home. When I came home last time, when I was on probation, I took it then.
And you took it before that too.
That was
on a previous
Evolve.
case. Yeah, you took it in the facility in the past too.
Yeah, and
taken
Evolve.
it a bunch of times. Yeah, Evolve. I heard you. Yeah, we know what the program's about, but I mean, why isn't it sticking when you take the program?
Like I told you, during the death of my father, I just was in a dark place at that time, and that's one of the reasons why I'm asking if you can help out so I can speak to a therapist. I don't adjust my feelings to nobody. I always bottle everything in, and then at that time it just. And I apologize for that, but I've been asking for help,
Which case is that?
Huh?
All right. So are you with any of these women currently?
No.
Do you have a new girlfriend?
No. I'm more worried about myself right now, getting myself back situated, especially mentally.
Smart. Yeah.
Especially mentally, and everything. So I just need to get myself back right and on track.
Yeah. It's a lot. You understand, right? Our concern for the community, all the women out there. It really is a lot to overcome, sir.
No,
I'm glad you have the 4 years of special parole, because you need that supervision, you need programming, you need help.
Yeah, and I'm definitely willing to do them things to show initiative, and I'm just asking for help, and I'm asking for another chance. That's all.
Okay, Mr. Rodriguez.
I don't have any questions, Madam Chair.
All right, give us a few minutes to discuss your case. We're going to deliberate briefly, and we'll give you our decision.
Thank you so much, and God bless y'all.
All right, so there's no way I would vote Mr. Randolph to discretionary parole, given the multiple incidents of domestic violence and the concerning history of domestic violence. But luckily for him, he's got 4 years of special parole to follow his sentence, so he'll get the help that he needs with the strict supervision that the community needs.
Yeah.
For reasons for denial, nature and circumstance while on probation, and criminal history.
Yeah. Try to get beyond any of that.
All right. So for conditions, I have 3 victims. I have an RA, an LR, and an RS. No alcohol consumption, domestic violence program in the community, and halfway house placement.
There's several other care protective orders that are
currently?
There are, but they're unrelated to the instant offenses. So, I mean, he can't break the law anyway, right?
You said mental health evaluation too.
I did not. He's in mental health 1. I know he wants to go to counseling, but I don't know that I would stipulate it given that he's a 1 and he's not receiving any,
Yeah.
right? I don't know. What are your thoughts?
I'm good.
Is there anything further? In the matter of Jason Randolph, MA number 292375, I'll move to deny parole at this time for the following reasons: the nature and circumstance of the offenses, offense committed while on probation, and criminal history. He has 4 years special parole to follow this sentence. Further move to set the following special parole conditions: no contact with victims RA, LR, or RS, no alcohol consumption, domestic violence programming in the community, and halfway house placement. Is there a second?
Second.
All in favor?
Aye.
Aye. Okay, do you understand? You'll get these conditions in writing. You're going to finish out this sentence. It ends early next year, the earlier part of next year. Is it March? I don't know what is estimated.
March 20.
Yeah.
Yeah. March
Okay.
20th, yeah.
And then you'll start your 4 years special parole. We'll send you to a halfway house and stay away from all of your victims. No alcohol use. You're going to do programming in the community for domestic violence. Okay.
So when you say for special parole, well, I don't go home on special parole?
You asked for a halfway house. Do you not need a halfway house?
Oh yeah. I asked for a halfway house. So with the, because I did my halfway house things too. So do I be able to see y'all for the halfway house, or?
Well, that's a whole separate process through the Department of Correction. Is that what you're talking about? That's
Yeah.
community release. So you talk to your counselor about that. We have no say in halfway house releases through DOC.
Yeah, because I finished the class on the 1st. So I don't know. I ain't know if the halfway houses was together or not. That's why I'm confused. I don't know.
Now, one of the process, you've been denied parole. So you can go out on a halfway house through DOC if they approve you. You know, they want to put you there, and then you start your special parole from there when your sentence is over.
All right.
All right. Good luck. Keep working on yourself, sir, please.
No problem. Have a good day. God bless you.
And a shocking surprise with a denial by the Connecticut Parole Board. But thankfully, in the state of Connecticut, they have this thing that they call special parole. That means that the judge can bake into the sentence at the time of sentencing a mandatory parole period. So he was denied, had to serve the remainder of his sentence, but then was put out on parole thanks to the light on crime, agenda-driven judges and DAs. I think, though, that the state of Connecticut has their system right. I think that the state of Connecticut understands that being light on crime, that giving 5th, 6th, 7th, 8th, 9th, 10th chances is the best way for rehabilitation. As a matter of fact, as Dr. Grande says, I am willing to say with absolute certainty that Mr. Randolph will never be convicted of another violent offense again.
Good morning.
Good morning, Mr. Randolph. How are you?
I'm all right. How you doing?
Gosh darn it, Randolph. We were all. How is it possible that you committed another violent offense? And yes, guys, I want to state for the record that he lasted 4 months before getting revoked, and he got revoked after he was convicted of threatening physical second degrees, threatening to physical. He has another conviction. He landed another conviction. We are about to go through the parole revocation process. But before we do, I need to paint the full picture so that you can see just how insane these DAs, and remember, they had a standoff. They had the SWAT team there. Look at what they did. Let me just show you. And again, keep in mind that the state of Connecticut only shows records of 10 years. Sir Richard was able to find this other information. He has 5/2/2012 assault 3rd degree, 4/5/2014 strangulation 2nd degree, 5 years, but they suspend after 18 months. Violation of probation in 2018. Here's a 2014 burglary 2nd degree. So in between the strangulation, the burglary, had a 9-year suspended after 42 months. This is what he violated the probation on. 2023, 5 probation, I don't know. 2017, another strangulation, 10 years, suspended after 1 year. Can you imagine? They suspend a 10-year sentence to just 1 year. And it's like, why is he not? So if you owe the state of Connecticut 9 years, how is it possible when you get a SWAT team called on you that you only get a 2-year sentence? He violates probation here. He violates probation here. He gets another strangulation in 2022, attempted to commit burglary, failure to appear, threatening in 2023, another strangulation, interference with an officer, escape 1st degree. In 2025, I guess he ran away from the halfway house. I'm guessing we're going to find out in the revocation process. And here it is, the conviction, 4/18/2026, threatening physical threat. And the reason that we're seeing his revocation hearing now is because he had to go through the system. He had to go through the process of dealing with this conviction. So thank you, Sir Richard, for not only pulling the research, but keeping track and connecting the dots. Now we're going to go and watch this revocation hearing. Again, remember, his initial parole hearing that we just saw happen in 7/22/2024. He would have gotten out in 2025, and it looks like immediately he escaped. But we'll find out. I'm not entirely sure. I haven't watched the revocation hearing yet, so let's jump in.
So we'll now review the charges that the state your parole officer is bringing against you and the information underlying each charge. So charge number 1, the condition of drug testing. The charging officer reported that on 4/6/26, you rendered a urine analysis at Chase Halfway House. Your results were positive for cocaine and you denied usage, so your specimen was sent to Redwood Toxicology Laboratories. Said provider confirmed you were positive for cocaine. Charge number 2, the condition of program participation. The charging officer reported that on 12/30/2025, you were referred to the domestic violence per your special parole conditions. Your scheduled intake was on 1/22/26 at Wheeler Clinic, located on Lakewood Road in Waterbury, Connecticut. You participated in your intake and was informed by your treatment provider your schedule would be each Thursday, 5:45 p.m. to 7:15 p.m. Chase Halfway House Chase Halfway House also issued you passes for aforementioned treatment groups. You attended all your sessions since 1/22/2026, and on 4/9/26, you were supposed to attend your domestic violence program. You deviated after leaving work at 4:06 p.m. to head to a check cashing store without an approved community pass from the Halfway House. You were in violation of your Halfway House agreement. Yeah. And then on charge number 3, the condition of obedience to the law, the charging officer reported that on 4/18/26, you were in a verbal and physical altercation with another offender at Chase Halfway House. The incident stemmed from Rosa being in the bathroom too long and you wanted access to the bathroom. Upon Rosa exiting the bathroom, you were seen on video surveillance having words with Rosa. Her Halfway House staff, Ruben, he had to intervene as you were heard saying, "I will fuck you up. I'm going to punch you in the face," and you mushing/pushing offender. You reported needing to use the bathroom and Rosa told you to leave. You waited 20 minutes. You reported when Rosa left the bathroom, he told you, "Yeah, you had to wait for me." You admitted to yelling at Rosa but denied threatening him. You also informed the trooper that you believe Rosa had stolen $40 from you, but you had never reported it to Halfway House staff. CT State Police arrived on scene and conducted their investigation. Based on their behavior, CSP charged you with Connecticut General Statute 53A-182, disorderly conduct, and Connecticut General Statute 53A-62, threatening second. Charge number 4, the condition of no consumption of alcoholic beverages. The charging officer reported that on 3/4/2026, you returned back to Chase Center from your treatment group at Wheeler Clinic. You were given a urine analysis, which was positive for alcohol. Your sample was sent to Redwood Toxicology Laboratories, which was also confirmed for alcohol. On charge number 5, the condition of Halfway House placement. The charging officer reported that on 2/1/26, you were given a community pass to attend church. You signed out of Renaissance East at 10:47 a.m. with a scheduled return time of 12:47 p.m. At 1 p.m., you called the Halfway House to report you were on the corner and would be back shortly. You returned to the halfway house at 1:14 p.m. When asked why you were late, you responded, "I was on the bus. It ain't no big deal. Why are you making a big deal about it? It's not that big of a thing because I was late." You were unaccountable in the community for 13 minutes. 3:23:26. You were supposed to return to Chase Halfway House at 4:30 p.m. You called the facility at 4:15 p.m. to report you'd be late. You were given a new return time of 5 p.m. Halfway House remained in contact with you by initiating calls at 5:15, 5:30, 5:45, and 6 p.m. to check the status of your arrival. You arrived at 6:03 p.m. You were unaccountable in the community for 1 hour and 3 minutes. On 4/2/26 at 7:48 a.m., you came to the front office of the Halfway House to sign up for your chiropractor appointment at 9 a.m. in New Haven. You could not sign out due to the system rejecting your pass. You were supposed to sign out at 7:15 a.m. in order to catch the bus and on time to arrive for your appointment for 9 a.m. Due to the tardiness of your part, your pass was denied because you would now arrive an hour past your appointment time. Staff tried to explain this to you, but you were responded with, "Well, I'm done talking to you, you always extra." You tried to speak with the program director and he requested that you give him a minute as he was dealing with 3 other offenders at the time. Once he was able to speak to you and he repeated the same information for why your pass was denied, you became disrespectful by swearing at the program director. You further stated, "This is why I walk out." That's fucking bullshit. There's always a fucking issue. "You know I'll be out, Lou. You know I'll be out. That's why I left the last time." You later returned to the office requesting a common pass to get your W-2. You were informed by staff that common passes are required to be submitted 3 days ahead of time. You became upset again and swore at staff. On 4/9/26, you were supposed to attend your domestic violence program at Wheeler Clinic that you referred to on 12/30/25. Your scheduled intake was on 1/22/26 at Wheeler Clinic, located in Waterbury, Connecticut. You participated in your intake and was informed by your treatment provider your schedule would be each Thursday, 5:45 p.m. to 7:15 p.m. Chase Halfway House issued you community passes to attend your DV group. You attended all your sessions since 1/22/26 as per your special program. On 4/9/26, you deviated after work at 4:06 p.m. to head to the check cashing store without an approved community pass from the Halfway House. 4/10/26, you were given a pass for work. You were scheduled to return at 5:30 p.m. Staff tried to call you twice at 5:40 p.m., but you did not answer your phone. Staff attempted to reach you via your phone again at 5:45 p.m. and no avail. You finally returned to the Halfway House at 5:55 p.m. You were unaccountable in the community for 25 minutes. On 4/17/26, you called the Halfway House and reported that you'd be 5 minutes late from your usual scheduled return time at 5:30 p.m. Halfway House informed you that your scheduled return time was actually 5:45 p.m. and you wouldn't be late. At 5:56 p.m., you still had not returned to the Halfway House. At 5:58 p.m., Halfway House staff contacted you via your cell phone. You reported you were currently downtown. You were instructed to return to the Halfway House immediately, and you arrived at the Halfway House at 6:23 p.m. You were unaccountable in the community for 38 minutes. The state has filed the following exhibits that have been marked for identification purposes as Exhibit A, the remand to actual custody. Exhibit B, the parole conditions. Exhibit C, the Halfway House agreement. Exhibit D, the notice of parole violation. Exhibit E, the notice of parolee rights. Exhibit F, the parole violation report. Exhibit G, the incident reports. Exhibit H, the residential discipline reports. Exhibit I, the offender misconducts. Exhibit J, the redwood toxicology report. Exhibit K, the misdemeanor summons complaint MC 790736. Exhibit L, the criminal appearance bond, and Exhibit M, the CTD DSPP investigation report. Counsel, to confirm, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes, we have. Thank you.
Thank you. And I did receive documents from the defense. They were a little bit close to the hearing, so I didn't get a chance to fully review them. Would you like me to admit them into evidence, or will you be testifying towards them?
If you could admit them into evidence, that would be great. Thank you.
Okay, so I'm going to just take a moment and read it. Well, I'll read this one quickly.
Yeah, and
Listen, where is that noise? Do you hear that noise? Is that New
It's
Haven?
in the background of New Haven.
Yeah, that's
Is it? Oh,
Yeah, that's somebody that's next.
Oh,
Who's
it's with
doing
you?
it?
Okay, I couldn't see the screen moving. I wasn't sure if it was coming from there. Okay, thank you.
No problem.
So I did receive 2 exhibits from the defense. I'm gonna, do exhibit 1 is the letter, calling this witness letter. That's all right, witness letter. And exhibit 2 is the judicial branch case detail. All right, and we do not have, do you need time, counsel, to submit any other evidence?
No, we do not. Thank you.
We do not have any witnesses. So at this time, it is the defense's opportunity to make a short statement and testify with respect to probable cause and the severity of the allegations.
Yes, thank you very much. I do just want to start by noting some of the history with my client and this particular halfway house involved in the majority of these violations. He reports that there were prior issues when he was there previously while on parole, and that a number of staff members there he felt were intentionally targeting him due to these prior issues. When he was told where he was going and that he was going to be placed at Chase Center, he reports that he did basically everything short of begging his PO to be brought to a different halfway house just due to that prior history and his concerns. He reports there being an ongoing issue once he did arrive there with his pass submissions, where he would put in for a pass, but then be told they didn't receive that at the last minute. He did try to voice his concerns about this to other staff, but continued, unfortunately, to experience these problems there. Concerning the specific charges, as to the first charge, drug testing, I would argue that there's no allegations or evidence that my client failed to comply with drug testing when requested. As to charge 2, program participation, I would argue that there should be a no finding on that charge. Specifically, I would argue the portion of the charge concerning deviating from the halfway house pass does not meet the elements for that specific charge. Additionally, I would just like to ask my client a couple of questions because I do think they're relevant. Mr. Randolph, can you please explain the situation that occurred with the money order on the date that they're saying you had missed your DV class?
Yeah, I had spoke to the counselor and everything for the pass, and they said that I have enough time and that I could go and get the money order, because the money order was for the house. I had to pay $150 for staying there at the house for my check. So they told me to go there first and then go to DV class. I got the DV class like 18 to 20 minutes late, so I was past the 10-minute mark of being allowed in. But I attended all my classes. I never missed a class or nothing, but that's the only reason why I was late. So
Thank you very much. I appreciate that. I would also argue, furthermore, in addition to this, as my client noted, he did only miss this one appointment. He had been in DV programming since he got back out. It says that he did his first intake January the 22nd, I believe, and he, to my understanding, had continuously attended. This was the only time when he missed, and he did testify as to the reasoning for that. As to charge 3, obey all laws, I would just argue, my client did receive a fully suspended conditional discharge with no additional probation or time to serve, which I think shows that this was not considered to be of a particularly serious nature by the prosecution who made the offer, and also the court who did accept that offer. I will note that we did include a statement taken from a roommate of my client in the halfway house, where he indicates that he didn't observe any, physical or threatening behavior on my client's end. However, for the sake of resolving the matter, my client was amenable to accepting the state's conditional discharge offer. As to charge 5, halfway house placement, I would note for the 2-1 incident, my client was only 13 minutes late for his return, and he did call the halfway house, as is stated, to give them a heads up that he was going to be late due to the bus. My client does rely on the bus for transportation to and from his appointments and also his work. And there are, unfortunately, some unforeseen delays by, just virtue of the way that system works. But I would argue that, certainly the 13 minutes, I think, is not an egregious variation. And again, he did call to give them a heads up about that. As to the 323 incident, I would note it shows in the disciplinary report for that staff were in contact with my client. They say, quote, constantly throughout the hour he was allegedly running late. And he first initiated a call with them to give them a heads up, and then again, remained in contact with them throughout. So I would argue this, there should be a no finding on that. This was a situation, again, where he was returning from a doctor's appointment far off in New Haven, ran into traffic on the highway. Again, sometimes there are unforeseen delays, but he was, to his credit, keeping in constant contact with his PO. And I don't think that that's the type, or not necessarily his PO, but the staff at the halfway house. And I don't necessarily think that that's the type of behavior that we should be penalizing when somebody is conscientious and tries to stay in touch and keep someone aware of their whereabouts. On 4/10/26, I will note my client, again, was only 25 minutes late at another situation, was returning from an appointment. The bus delayed him. He did state that he showed staff upon return that his phone was dead, and that was why he was unable to contact them, as he did, typically do the right thing and always contact them. And then as to the 4/17 date, I believe that this was, again, another incident of my client relying on the bus system and running late due to that. But he did, again, call them even prior to being late to give staff a heads up, at least an hour in advance, that he was going to be late just due to the way that the bus system was running that particular day. In addition, I would argue that these allegations are not serious enough to warrant revocation of my client's parole. He did, again, not receive any time or probation in court, which I do think weighs in favor of it not being substantially serious. Additionally, he reports doing some positive things in the community. He was engaging in the DV programming through Wheeler Clinic. Again, as you heard, he only missed that one session. He also reports he was doing outpatient services through Wheeler Clinic on his own as well, which he found to be helpful. He was employed working at Percolux and Waterbury. Furthermore, I would note that the evidence submitted by PCS does appear to show that he is someone who tried, I think, to be very conscientious and communicative with parole if he was ever running late or deviating from his return time on passes. Mr. Randolph, is there anything pertinent to the charges or the seriousness that I didn't cover that you want to say at this time? You don't have to, just if there's anything I didn't include.
No.
All right, thank you.
Thank you.
That way.
So I'm going to announce my findings, Mr. Randolph. So on charge number 1, the condition of drug testing, I'm making no finding of probable cause as the state failed to submit sufficient evidence in support of the charge and the elements were not met. On charge number 2, the condition of program participation, I'm also making no finding of probable cause. Again, the state did fail to submit sufficient evidence in support of the charge and therefore the elements were not met. On charge number 3, the condition of obedience to the law, I am making a finding of probable cause. As counsel's exhibit 2 shows and statements taken today, you were convicted of that threatening second charge when you received that suspended sentence. In addition, the evidence in support of that charge is states exhibits B, F, G, K, and M. Also making a finding of probable cause for charge number 4, the condition of no consumption of alcoholic beverages based on the evidence presented in states exhibits B, F, G, H, I, J. And charge number 5, the condition of halfway house placement, I have separated that charge into different parts, each part associated with a date as charged, and I'm making a partial finding. So I'm going to make a no finding of probable cause for the dates of March 23rd, 2026 and April 9th, 2026, as the state failed to submit sufficient evidence in support of those 2 dates. I am going to make a finding of probable cause on the remainder of the dates of the charge based on the evidence presented in states exhibits B, C, F, G, H, and I. I am also finding that the acts are serious enough to warrant revocation. And I determine that you should be detained while you await that revocation hearing. So what happens next, Mr. Randolph, is that I will let your officer know and the records facility, the records office at the facility know, and we will work on scheduling your revocation hearing within 60 business days of your remand to custody. At that revocation hearing, myself or another hearing examiner will determine if you have violated the conditions of your parole. And if so, we'll make a recommendation regarding the whether or not your parole should be revoked and what, if any, sanctions should be imposed. So that does conclude today's hearing. Do you have any questions?
Sir, I will get in touch with you as soon as I can. I will be out next week, but I'll get in touch as soon as I can the following week. And I will have someone from my office send the case info to ask your PO to submit the needed paperwork. Okay.
All right. So we'll do.
Oh, you're right.
I just gotta.
So now It'll be about a month or so, give or take, and we will come back for a second hearing. And it's a higher burden of proof for the state at that hearing, and we'll get another chance to argue some of this stuff.
Yeah, and thanks for correcting me, Attorney Jean. You're right, it is a criminal charge, so I do need that addendum submitted by PCS to get that hearing scheduled. Yeah, so once we receive that paperwork from PCS, your charging officer will get you scheduled for that revocation hearing, okay?
All right. What's PCS?
That's Parole Community Services. Sorry.
That's okay. Yeah,
And,
that's the people you report to in the community.
And Mr. Randolph, my social worker will also be reaching out to get information from you as well.
All right.
All right, thank you.
This does conclude the preliminary hearing for Jason Randolph, inmate number 292375. All right, we'll see you soon, hopefully, Mr. Randolph, okay?
All right, have a great day. God bless.
You too.
Thank you. Bye-bye.
And that was a preliminary hearing. And as you can see, the reviewers like, oh, well, I'll find findings here, but not findings there. And, just need to point out the PO officer didn't show up. So normally the PO officer is at these review hearings and they will have an adversarial hearing, PO officer against attorney, PO officer running around chasing kittens, herding cats without a law degree, facing an attorney with a law degree, and also the board reviewer viewing it as an adversarial proceeding where the PO officer has to prove that the person did something wrong. We have seen cases where they get the date wrong in the form and the PO officer will throw out everything because the date is not there. Or the Celebrate reports that did the investigation into the phone weren't submitted on time, so you can't be used. So yeah, I know there was CP on the device, but we have no proof of it. I'm not kidding. So the PO officer didn't show up probably because they're like, I just don't have time for this. We know there's a conviction anyways. Let's see what's going to happen. But we're now going to see the official revocation hearing where they only look at the findings and then it will go to the board review. So let's jump in.
So now I'm going to review the charges that the state, your parole officer is bringing against you and the information underlying each charge. Before we get started, though, I do want to note on the record that no finding was made for charge number 1, the condition of drug testing, charge number 2, the condition of program participation, and charge number 5, the condition of halfway house placement. The 2 parts dated 3/23/26 and 4/9/26. No findings were made at the preliminary hearing and no new evidence has been received from by Parole Community Services. So that information, those charges against you are not going to be taken into consideration at today's hearing. So I'm going to start reviewing the charges at number 3, the condition of obedience to the law. The charging officer reported that on 4/18/26, you were in a verbal and physical altercation with another offender at Chase Halfway House. The incident stemmed from Rosa being in the bathroom too long and he wanted access to the bathroom. Upon Rosa exiting the bathroom, you were seen on video surveillance having words with Rosa. For Halfway House staff, Ruben, he had to intervene as you were heard saying, I will fuck you up, I'm going to punch you in the face, and you pushing offender. You reported needing to use the bathroom and Rosa told you to wait. You waited 20 minutes. You reported when Rosa left the bathroom, he told you, yeah, you had to wait for me. You admitted to yelling at Rosa but denied threatening him. You also informed the trooper that you believed Rosa had stolen $40 from you, but you never reported it to Halfway House staff. CT State Police arrived on scene and conducted their investigation. Based on your behavior, they charged you with Connecticut General Statute 53A-182 disorderly conduct and 53A-62 threatening second. On charge number 4, the condition of no consumption of alcoholic beverages, the charging officer reported that on 3/4/26, you returned back to the Chase Center treatment group at Fabulous Clinic. You were given a urinalysis, which was positive for alcohol. Your sample was sent to Redwood Toxicology Laboratory, which was also confirmed for alcohol. You are in violation of your special parole condition that states throughout your period of parole, you are prohibited from the consumption of alcoholic beverages. And charge number 5, the condition of Halfway House placement, the charging officer reported that on 2/1/26, you were given a community pass to attend church. You sent out at Renaissance East at 10:47 a.m. with a scheduled return time of 12:47 p.m. At 1 p.m., you called the Halfway House to report you were on the corner, would be back shortly. You returned to the Halfway House at 1:14 p.m. When asked why you were late, you responded, I was on the bus, it ain't no big deal. Why are you making a big deal about it? It's not that big of a thing because I was late. You were unaccountable in the community for 13 minutes. You were in violation of the Halfway House agreement that states I will return to the Halfway House for my community pass at my scheduled return time. On 4/2/26 at 7:48 a.m., you came to the front office of the Halfway House to sign up for your chiropractor appointment at 9 a.m. in New Haven. You could not sign out due to the system rejecting your pass. You were supposed to sign out at 7:15 a.m. in order to catch the bus to arrive on time for your appointment at 9 a.m. Due to this tardiness on your part, your pass was denied because you would now arrive an hour past your appointment time. Staff tried to explain this to you, but you responded with, "Well, I'm done talking to you, you were always extra." You tried to speak with the program director, and he requested that you give him a minute as he was dealing with 3 other offenders at the time. Once he was able to speak to you and he repeated the same information for why your pass was denied, you became disrespectful by swearing at the program director. You further stated, "This is why I walk out. That's fucking bullshit. There's always a fucking issue, and you know I'll be out, Lou. You know I'll be out. This is why I left the first time." You later returned to the office requesting a community pass to get your W-2. You were informed by staff that common passes are required to be submitted 3 days ahead of time. You became upset again and swore at staff. You were in violation of your halfway house agreement, which states, "I will treat others with respect and not engage in verbal or physical altercation with other offenders, staff, or third parties." On 4/10/26, you were given a pass for work. You were scheduled to return at 5:30 p.m. Staff tried to call you twice at 5:40 p.m., but you did not answer your phone. Staff attempted to reach you via your phone again at 5:45 p.m. with no avail. You finally returned to the Halfway House at 5:55 p.m. You were unaccountable in the community for 25 minutes. On 4/17/26, you called the Halfway House and reported you would be 5 minutes late from your usual scheduled return time of 5:30 p.m. Halfway House informed you your scheduled return time was actually 5:45 p.m., so you wouldn't be late. At 5:56 p.m., you still hadn't returned to the Halfway House. At 5:58 p.m., Halfway House staff contacted you via your cell phone. You reported you were currently downtown. You're instructed to return to the Halfway House immediately. You arrived at the Halfway House at 6:23 p.m. You were unaccountable in the community for 38 minutes. The state did file an addendum to the parole violation report on May 21st, 2026. And that states that on April 18, 26, offender Jason Randolph was issued a summons for the disorderly conduct and threatened a second. And on May 14th, the charges or just the charge of disorderly conduct was nollied, and that you received, for the threatening second, you received 364 days in jail, execution suspended, followed by 1 year of conditional discharge. So counsel, to confirm, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
We have, yes.
I have one exhibit from the defense. I have exhibit 1, the list of parole accomplishments and future plans for parole reinstatement. Counsel, do you need time to submit any other documents?
I would not. I would also just incorporate the evidence that we had submitted for the preliminary hearing as well.
You're right. So I'm actually going to identify the list of parole accomplishments and future plans for parole reinstatement as exhibit 3, because exhibit 1 was identified as the witness statement and exhibit 2 was identified as the judicial case details for docket ending in 954S. So 3 total, correct, counsel?
Yes, thank you.
Perfect. And so we do not have any witnesses. So at this time, it is the defense's opportunity to present evidence and speak to the evidence submitted. So counsel?
Yes, thank you. As to the charges, I would just renew the arguments and testimony that were put on the record at Mr. Randolph's preliminary hearing. Unfortunately, during this period of parole, once he had left Renaissance East and gone to Chase Center, there was sort of this repeated continuous issue of him putting in for passes and there being inevitably some sort of issue with the pass. He did, I know, speak with counsel that he had for a civil matter, and the secretary in that office was helping him document this because he was, concerned that it would come back and be an issue, even though he was trying to be vocal and very upfront about the passes that he needed. He reports there, unfortunately, being some issues that he wasn't expecting when he would go for his typical pass on certain days. As to the obey all laws charge, my client previously noted that he did receive a fully suspended sentence of a conditional discharge, no additional supervision or time to serve. We did previously submit as well a statement from a witness of that alleged incident, indicating that he did not observe any threatening behavior on Mr. Randolph's end. And then as to the charge 5 halfway house placement, I know there previously was no finding for the dates of 4/9 and 3/23. I would just note for the 2/1 incident, my client was only 13 minutes late for his return, and he did, I believe, call the halfway house to give them a heads up he was late due to the bus running behind. On 4/10, he was 25 minutes late, and it does show in the incident report that upon his arrival, he showed his phone to staff and indicated that it was dead. Or else he would have called them, as he regularly did, to give them a heads up. Same with the 4/17 date, another incident of him relying on the public transportation system and running late due to that. But again, I do believe that he called on that date to give staff a heads up about his return time. My understanding is that he was conscientious when it came to his passes and was always trying to keep staff aware of his whereabouts. And sometimes, unfortunately, there are unforeseen delays when relying on public transit that are out of his control. But my understanding is that my client did do his best to keep in touch and let staff know where he was at each time. Thank you very much.
Thank you. And just Cass, to confirm, you said the 4/10 date was the date that the phone was dead?
Yes, the 4/10/26 date. It was a 25-minute, I believe, late return time. And I believe in that misconduct. I don't think I put the specific exhibit. I could find that. I believe that they did indicate that there was a dead battery.
So on charge number 3, Mr. Randolph, I am finding that you violated the condition of obedience to the law based on your conviction of the threatening second from May 14th, when you received that suspended sentence of 364 days in jail, followed by the 1 year of conditional discharge. In addition, the evidence in support of the charges states exhibits B, F, G, K, and M. So finding that you violated charge number 4, the condition of no consumption of alcoholic beverages based on the evidence submitted in states exhibits B, F, G, H, I, and J. And I'm also finding that you violated charge number 5, the condition of halfway house placement based on the evidence presented in states exhibits B, C, F, G, H, and I. So that does conclude the fact-finding portion of this hearing. Before I make my recommendation, you'll have opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what outcome I recommend. So, counsel?
Yes, thank you. My client, Mr. Randolph, is 42 years old, born and raised in New Haven. He gets support in the community from his fiance and his cousin. He also does have 6 kids whose lives he is involved in, and he does pay child support. Upon release of special parole in December of 2025, my client was first at Renaissance East. He did unfortunately suffer an accident there when he fell on ice, and then was transferred to Chase Center, where he remained until remand. He was working per diem through Pergolux and Waterbury. He also was engaged at Wheeler Clinic, where he had participated in Explore. He had completed approximately 15 sessions. He was also doing individual therapy there, and then an additional grief group to process the recent death of his father. He was working as well with a chiropractor to treat the back injury and his neck injury after falling on that ice that I had mentioned. He was also attending church at Zion Baptist in Waterbury. Since remand, my client was employed at the kitchen and New Haven Correctional prior to transferring to Robinson. He is heavily engaged in church services at the facility twice per week, including Bible study and choir, and receives support from his pastor there. Upon reinstatement of parole, my client would like to be sponsored by his fiance at the address we provided. He's open to also utilizing a sober house as an alternative if for some reason the sponsor is not approved. Plans as well to obtain a forklift certification and enroll in trade school to study electrical to further his career opportunities. He is hoping when he's released to utilize the staffing agency that he previously was working with, We Staff, for immediate placement. He also has been having his partner look into some jobs for him, and she's been helping kind of connect the dots for him while he has been incarcerated. He's very eager to reunite with his kids and be present for his oldest son, who very unfortunately recently lost his mother and has been grieving that loss. My client's open to any sort of treatment recommended, including returning to Wheeler Clinic and doing the Explore program. I am asking that you would consider reparoling my client on the first available board review day of July the 9th, I believe. He was on parole since December. This is his first violation. He had been doing well. As I noted, he was being very communicative. He was working with his PO, being present for his kids, and was heavily engaged in treatment. And he did have the added support as well of his family and church community. Mr. Randolph, is there anything I didn't cover that you want to say at this time?
No.
Thank you.
Thank you. All right, so I have listened to the testimony today. I've also reviewed all the evidence presented. As counsel stated, I know this is your first violation of special parole. However, it is a criminal violation and you did receive a conviction for it. Also, I have that you were only in the community for approximately 4 months between your release to supervision and your remand to custody. Parole and Community Services has recommended a 4-month sanction. So with that, Mr. Randolph, I am going to recommend your parole be revoked and that you serve an approximate 4-month period of confinement as a sanction. That's with the re-parole date of August 18th, 2026. Just confirm my date. That's when you came in, right? Yes. So August 18th, 2026. Tuesday. I'm going to recommend the following conditions: no consumption of alcoholic beverages, behavioral management program for domestic violence, no contact with victims RS, LR, or RA, a general no contact with AR, and halfway house placement just as a backup plan if needed. But I will note that you would like to be released to your, or have your fiance be your sponsor. I'll put her information in the system. So what does happen next, Mr. Randolph, is that my recommendation is going to go to the board on July 9th. On that date, the board can do 3 things. They can lessen my recommendation if they choose to do so. So any date between July 9th and August 18th. They can adopt that recommendation if they choose to do so. And then if for any reason they would want to see a longer period of confinement as a sanction, they'll ask you to come back for a 3rd hearing to address their questions and concerns before anything longer is imposed. So it does conclude today's hearing. Do you have any questions?
Nah.
Jason, I can set up a call either with you or I can give Jamila a call on the 9th to let you guys know what the board does decide.
All right, you can do both. Set up a call with me and reach out, please.
Absolutely. Thank you.
Thank you. Y'all have a great day.
This does conclude the revocation hearing for Jason Randolph at number 292375. Good luck to you, Mr. Randolph.
All right, thank you. Have a great day.
Thank you. Thank you, Attorney.
Take care,
Dean.
everyone.
All right,
Thank you. Have a great day.
You too.
A 10-month sanction. A new conviction on all they say is a 10-month sanction. I mean, really, you know, okay, but before I lose my mind, let's see if the parole board can decide. They can rescind it. They can make a different decision.
So today is Thursday, July 9th, 2026. Board members, please state your names for the record.
Jennifer Zaccanini.
Councilmember Rodriguez.
This is a final verification for Jason Randolph, 292375. Recommend revoking parole on August 18th, 2026, which is an approximate 10-month sanction. Just double check. Sorry, it's a 4-month sanction.
Yeah.
Does the board accept or reject this? The following conditions: no consumption of alcoholic beverages, behavioral management program for domestic violence, no contact with victims RS, LR, or RA, general no contact with AR, and halfway house placement. Does the board accept or reject this recommendation?
Mr. Rodriguez,
Yeah.
Mr. Poole. All right. In the matter of Jason Randolph, I'll move to accept the recommendations of the hearing examiner. All in favor?
Aye.
This concludes the final ratification for Jason Randolph, number 292375.
Nope, they agree. And let's keep in mind, he is on special parole until 2029. Ladies and gentlemen, we are going to see him again. How is it possible that he has this long record? He has this long record, and a SWAT team extracts him from the situation. They give him just 2 years, even though he owes so many. He gets out and immediately collapses, actually catches a new charge, and they're going to now re-parole him with the 2029 EOS date. It's what do they expect, guys? If you care for him, if you actually if you have empathy for him, if you have compassion for him, you would lock him up longer. Because remember, he didn't take you believe in the programs. Are you a program? Do you believe in the Kool-Aid program? Kool-Aid, yeah, you do. So then you keep him longer. Then you make sure he does programs. What will releasing him out in the street do? Nothing. And he has a fiance. Can you imagine a bloody fiance? That's really a great way to go about things, guys. I can't with this anymore. It's so insane. But we're going to go and jump into another one, another wonderful event, another wonderful scenario of hearings. So let's go.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. Charge 1, obedience to the law. On August 14th, 2024, you were spotted by law enforcement in Manchester driving a vehicle that had possibly fled from police weeks prior. You were reported as filling up your gas tank at a station, and when you saw the police, you jumped into the vehicle and looked to flee until police blocked your vehicle from leaving. Upon exiting the vehicle, you were detained. Manchester police then contacted your assigned parole officer and reported that they could see possible contraband. Parole reported on scene, and a subsequent search of the vehicle by parole officers yielded the following contraband: a large quantity of marijuana, more than allowed by law, several $1,000s cash arranged and ordered that is known to be commonly used in illegal drug transactions, a digital scale, a bottle of tequila, packaging baggies also associated with drug sales, and 2 cell phones that you told the officer were not his, so he did not have the code to unlock it. Due to your behaviors and actions, you were then arrested and charged by Manchester police for the following crimes: possession of greater than 8 ounces of marijuana in a locked container, possession with intent to sell, operating a drug factory, misuse of registration plate, no insurance, operating an unregistered motor vehicle, and illegal tents. Charge 2, search. On August 14th, 2024, during a search of your vehicle under your possession and control, 2 cell phones were found in the vehicle. The phones were locked, and upon being asked for the codes, you stated that the phones were not yours and did not have the codes despite being in the vehicle which you were the sole occupant and over which you had direct control. The state has filed the following exhibits: Exhibit A, remand to custody; Exhibit B, signed parole conditions; Exhibit C, notice of parole violation; Exhibit D, parole violation report; and Exhibit E, Manchester Police Incident Report. The state has filed an addendum to Exhibit D, which states the charge is possession of greater than 8 ounces of marijuana in a locked container, possession with intent to sell, and operating a drug factory was substituted to a legal sell, manufacture of cannabis. Mr. Smith was convicted and sentenced to 6 months jail under docket ending in 438. In addition, the charges of no insurance, misuse of registration plate, operating an unregistered motor vehicle, and illegal tents under docket ending in 772 were not prosecuted by the state. Counsel, did you receive the notice of parole violation report, and the other documents that were just marked for identification purposes? Yes. Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today we have no witnesses. It is now the defense opportunity to present evidence to speak to any of the evidence submitted. Counsel?
Yes, thank you. In regards to charge 1, obedience to law, my only comments would be that the 6-month sentence has been served as of today's date. In regards to charge 2 under search, my client does maintain that the telephones located in his car were not his, that someone else had left those phones in his car, and that he did not have access to the passcodes to provide those to his parole officer. There's no evidence submitted here to suggest that those phones do belong to my client. Even after they were seized, there's no further investigation to indicate that the phones were my client's cell phones. So we would submit there's insufficient evidence to support that charge, and nothing further as to the charges.
Thank you. I'm going to take a moment before I announce my findings. Regarding charge 1, obedience to law, I make a no finding on the following charges: no insurance, misuse of registration plate, operating an unregistered motor vehicle, and illegal tents, as these charges are motor vehicle infractions and does not constitute as crimes. I do make a finding on the rest of the offenses listed in this charge based on Mr. Smith's conviction, as well as State's Exhibits B, D, and E. On charge 2, search, I make a finding based on State's Exhibits B and D. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background history. Counsel?
Yes, thank you. Mr. Smith is 25 years of age. He's single. He has no children. He does have a strong family support system that consists of his mother, his brother, who both reside in the Hartford area. He did obtain his GED while he was in the community, which I believe he was in the community for approximately 18 months. And this is his first violation of this period of parole. He was first released to a halfway house, open hearth, and then transitioned to sponsor in East Hartford, where he and then later transitioned to self-sponsor in Hartford, before moving in with a girlfriend, who was his sponsor in Hartford. During the time period, the 18-month time period that he was in the community, he was gainfully employed, working construction, at a location in Hartford, as well as working for J&L Precision Cleaning. He also held employment with People's Choice in East Hartford, working as a chef, and with Laser Ship, in East Hartford, which is a warehouse similar to Amazon. During the time period that he's been with the Department of Corrections, and I would note that he has been incarcerated now for over 1 year, he has taken time to work on himself. He's been engaged in a program at Carl Robinson and called New Thoughts. He tells me that when he is re-paroled, he would like to sponsor. If I could just confirm that with him, actually. You did indicate that you wanted to sponsor to a girlfriend's house, but then you also indicated that you wanted to try to self-sponsor. Can you just clarify?
Yes, I would still be self-sponsoring, but as of right now, I don't have all the information I would have to give you guys. So I would just for the option, I'll just do half it else as of right now.
Okay.
So I can get that to you guys.
Okay, and what area did you want to do that? Hartford?
Oh, that was New Britain.
Okay, is there an area? Is there?
I believe it's New Britain, maybe
It's Hartford.
Hartford. I
Yeah.
think it's a Hartford area,
Okay.
but I would have to double, we have a chart. I don't know. It's off the top of my head, but-
Okay. All right, thank you. He does indicate that he has employment to return to, working at J&L Precision Cleaning. Also has an opportunity of working at Security Services through USA Security Services located in East Hartford. And then certainly he's amenable to all opportunities that might present themselves in terms of employment. Also amenable to all treatment recommendations. Again, at this point, he has been incarcerated now for over 1 year on a sentence that he received of 6 months on a court sentence. And again, I would note that he was in the community without issue for approximately 8 months. And again, this is his first violation of parole. So we would be asking that he be re-paroled at the next available date. Thank you.
Thank you. I'm going to take a moment before I announce my recommendation. Mr. Smith, I see that you were discharged of special parole in September of 2022. Since being discharged of special parole, I see that you were in the community for about 1.5 years. Within that time frame, there was no misconduct reported. This is your first parole violation. Only thing that was noted by PCS was this arrest. Taking into consideration that you did receive a new conviction and you were in the community for approximately 1.5 years, I recommend revoke and re-parole on August 28th, 2025, which is an approximate 1 year sanction, with the following conditions: no consumption of alcohol, no contact with co-defendant Cameron Mathis and Eli Jordan, no contact with victims JJ and NG, halfway house placement, mental health evaluation, and no operation of a motor vehicle without the express permission of your parole officer. My findings and recommendations will be forwarded to the board, and you will receive the official written decision from the board, and your board review is scheduled on August 28th, 2025. So my recommendation is that you're re-paroled that day. If the board agrees with that decision, you'll be released that day. If the board does not agree with that decision, you won't be released, and there will be another hearing that will take place because they would want to see further incarceration. Okay?
Okay.
So that does conclude your revocation hearing. Do you have any questions?
No questions.
Okay. Thank you. You're all set.
Good luck, sir.
Thank you. You guys have a good day.
You too.
An absolute grace by the parole review board. And I don't even need to show you what the parole board said because they agreed with the hearing examiner. You know, I think that a state that has a focus on second chances, third, fourth, fifth, and sixth as well, understands what it means to rehabilitate someone. They understand what it means to keep the community safe. They understand how to run their Department of Corrections. I say, with the utmost certainty, as Dr. Grande says, that without a shadow of a doubt, Mr. Smith will never get in a police pursuit again.
Morning.
Morning, how are you?
Good, thanks.
Good. You ready for Mr. Smith?
Yes, please.
That's good. You're right in.
Gosh darn it, Mr. Smith. How you keep. How did we. How is it possible? Guys, do you want to know something? He lasted 4.5 months before he ends up not just getting revoked, but getting in a high-speed police pursuit where he flips his car and ends up in the hospital. 4.5 months. And I gotta tell you, the blood should be on the hands of these agenda-driven DAs and the parole board members and all of these nut jobs. Let me just show you and read to you before we watch this revocation hearing what a chase this was. I know, here's our prince over here. Oh no, help me, I flipped my vehicle. Go spend more taxpayer dollars on me. Let me read to you the sequence of events. A white sedan swerved across lanes on Interstate 84, then took off when a trooper tried to stop it, sparking a high-speed chase that ended in a rollover crash that sent a Hartford man to the hospital. Mr. Smith, 25 of Hartford, was seriously injured and now faces multiple charges following the chase late Sunday, January 11th. The incident unfolded when a trooper spotted the white Nissan Maxima traveling east. Police said that the car made unsafe lane changes, failed to signal, and struggled to stay in lane. A registration check showed that the plate was canceled and belonged to a different vehicle. Oh no, how did that happen? Police also determined the car was uninsured. Oh, it's always uninsured. When the trooper tried to stop the car near exit 68 Holland, police say that the driver sped up, shut off the headlights, and drove recklessly through traffic at speeds exceeding 90 miles an hour. Mind you, he was also drunk. With no backup nearby, the trooper ended the pursuit. By the way, Connecticut has those really progressive laws where if you're going 90 miles an hour with the headlights off, they don't want to risk an injury. So they end the pursuit. Yes, that's Connecticut. The bad guys in the state of Connecticut, they're allowed to have extended 20-round, actually standard 20-round magazines in their Glock. But a good guy in Connecticut, you better not exceed 10 rounds because you don't want to have an advantage, or at least a fair advantage to the bad guy with 20 rounds, right? In Connecticut, if you run from the cops just stop chasing you because we don't want anything bad to happen. But what happens? Minutes later, a 911 caller reports a white vehicle speeding near exit 70 with no lights on. So police say the call raised additional concerns. Like, oh no, the guy that we just let out of jail for doing the exact same thing is doing the exact same thing. Who could have thought that might happen? Another trooper later spotted the car near exit 72 and 73 in Union. When police again tried to stop it, the driver fled. And again, the troopers ended the pursuit. Had this genius over here. I know his brain isn't fully developed. He's under 26. Let's see if his attorney uses that in his favor. He's still very young, so he didn't know. All he had to do was stop, and he would have gone away with it. He doesn't understand that. So they stopped the pursuit again, and guess what? He would have gone away with it. But soon after, police say the car lost control on I-84 at exit 74. It left the road, it hit a tree stump, and flipped over. So he flipped over all on his own, brilliant driving in his Nissan Maxima. Smith ran from the wreckage. He was so hurt, he ran from the wreckage, but was captured 300 meters from the crash site. We're seeing him now, by the way. You just can't make it up. By the way, the injury on his hand, this is not from the crash. The injury from his hand is because he got in a fight waiting for his revocation hearing. Yeah, he punched someone, and he probably broke his hand by punching someone. So that's all. But don't worry, guys. Don't worry. He's just a Beba Angel lad, and as actual justice warrior likes to say. State police say that Smith was on parole, unlicensed at the time of the crash, and police say he also showed signs of alcohol impairment. Because of the injuries from the crash, the troopers could not complete a full sobriety test. Police say that other indicators, including the odor of alcohol and Smith's driving, established probable cause for the operating under the influence. A search of the car turned up suspected marijuana packages, by the way, packaged to sell, consistent with sale, along with multiple alcohol containers. Smith faces charges of operating under the influence, driving without a license, reckless endangerment, sale of cannabis, multiple charges. And here, Sir Richard found the actual copy of the police report, the arrest warrant. Look at all of these charges. And I want to tell you that this agenda-driven district attorney's office, the same district attorney that had him on charges for doing the same thing that the parole board let him out, they null crossed every single one of these charges except for the illegal operation of a motor vehicle under the influence. So they null cross improper use, they null cross illegal without minimum insurance, they null cross reckless driving, they null cross engaging in a police pursuit, failure to drive lane, at least selling, manufacturing cannabis, so dealing, interfere with an officer in reckless endangerment. And wait till you hear what his attorney says. His attorney says, this police department is known to be one of the toughest in the entire state of Connecticut. I should say police department, the prosecution office. Guys, we are going to we are in the process of showing just how mentally ill the judiciary is in the state of Connecticut. This man is a one-stop. He's a destruction machine. Remember, let's look at his record. This is just talking about this. Look at his record. The state of, again, we're going to watch this hearing, but in 2019, he had larceny second degree, 620, right? 3 years ago. We know he got out on bond or whatever, because a month later he gets robbery threat first degree. Do you know what this robbery threat first degree? You know what that means? I know it sounds kind of innocent. It's like, oh, it's a robbery threat first degree. What? That can't be anything too bad, right? Well, let's go. I know that Sir Richard has the link in it. Here it is: robbery threat first degree. Hold on. I can't find the article, but it's with the firearm. Okay, he's using a firearm. Then he also has reckless endangerment. Then he has the 2024, the illegal manufacturing, right? 6 months jail, and then he gets all of these. Now, anyways, he has a long record. But let's go see what the revocation review board does in all of their wisdom. And okay, all right, let's jump in.
Okay, so we will now review the charge, state your full officers bringing against you, and information underlying each charge. So P.O. Davis, you could please read the charges as well as the addendum after.
All right. Obey all laws. Charge number 1, obedience to the law. On 01/11/2026 at 6:42 p.m., you were observed in a white Nissan Maxima traveling east on I-84 near exit 67, bearing CT registration AP 37937. You were observed by a Troop C Talon State Trooper changing lanes of travel for no reason. You were also not using your turn signal, and you were not maintaining proper lanes for extended periods of time. Your license plate came back canceled to a Pontiac Solstice. At this time, the trooper attempted to initiate a traffic stop with lights and sirens in the area of exit 68 in Tolland. You did not stop, instead increased your speed in an attempt to elude the trooper. You then shut off all your lights to your vehicle and continued to drive recklessly through traffic. At this time, the trooper stopped the pursuit per policy. Approximately 1 to 2 minutes later, Troop C reported a 911 call referencing your vehicle in the area of exit 70. You elevated the need to apprehend as you were continuing reckless and dangerous behavior. Another trooper near exit 72-73 in the town of Union started to engage in pursuit. After several seconds, you tried to exit on exit 74, left the roadway hitting a tree stump and flipping over on the exit ramp. You then proceeded to exit the vehicle and were running away from the scene. You were located hiding behind a metal guardrail approximately 300 meters from the vehicle's final rest. You had visible injuries to your face and hands, and you were soaking wet from running through the drainage ponds just off the exit ramp. Troopers also could smell alcoholic beverages emanating from the area of your face as you spoke. Troop C Tolland also later found out that you did not have a valid driver's license. Troopers had probable cause you were driving under the influence of alcohol. After a search of the vehicle, it was discovered that you had a large canvas bag with a large amount of suspected marijuana, which was packaged to be consistent with the sale and not for personal usage. Several containers of alcohol were also observed on the floorboards. You were then transported to Hartford Hospital by Willington EMS. Subsequently, you were arrested by Troop C Tolland and held on a $100,000 bond for the following charges: CGS 14-227A, operating under the influence of alcohol and or drugs; 14-222 *, reckless speed over 85 miles per hour; 14-223 in parentheses B, double asterisk, engaging police in pursuit; 14-236, failure to drive in proper lane; 14-147C, misuse of registration plate; 14-213B, no insurance; 21A-279A1, possession of a controlled substance; 53A-64, reckless endangerment second; 53A-167, interfering and resisting; and 21A-278B, C1, illegal selling and manufacturing of cannabis over 8 ounces. You were due to appear in court at GA 19 Rockville Monday, 01/12/2026 at 9 a.m. Your next court date, according to the state of Connecticut's judicial website, is 02/04/2026 under docket numbers T19R-CR26-0191161-S and TR19R-MV26-0278696-S. Charge number 2, drugs. On 01/11/2026, you were found to be in possession of 55 grams of suspected marijuana and several Ziploc bags, multiple containers of the Ziploc bags for suspected drug sales, 3 cereal milk, 3.5 gram packages of marijuana, and 1 Gary Payton 7-gram package of marijuana. You are not allowed to possess this amount of marijuana. Charge number 3, no consumption of alcoholic beverages. On 01/11/2026, Connecticut State Police had probable cause to believe you were driving a motor vehicle under the influence of alcohol. You also had multiple alcohol containers on the floorboard of your vehicle. You have a no alcohol condition on your signed parole, special parole conditions, and shouldn't be drinking or possessing any alcohol. Charge number 4, halfway house placement. On 08/28/2025, you were placed at the Watkinson halfway house and signed a halfway house agreement, abide by the rules of the house. On 09/28/2025, you were given an instruction by halfway house staff to leave the basement and go to your room during visitation. You proceeded to come into the staff office and stated to staff all visitors were present. Y'all do whatever the fuck y'all want. Make up shit where in the book is that a rule. You were again instructed by halfway house staff to go to your room, and you stated, "Man, word on my mother, I don't give a fuck, send me back. Y'all do whatever, dumb as fuck." This is a violation of your signed halfway house agreement. Specifically, I will treat others with respect and not engage in any verbal or physical altercations with supervised persons, staff, or third parties. On 10/19/2025 at 11:40 p.m., you were issued a pass to St. Francis Hospital to receive emergency medical care. Staff contacted the hospital to confirm your whereabouts and was told that you were not there. You returned to the halfway house at 3:34 a.m. with no discharge paperwork. You were unaccountable in the community for 3 hours and 50 minutes. This is a violation of your signed halfway house agreement. Specifically, I will not leave the physical confines of the halfway house unless authorized by program staff or parole. I will only go to the locations indicated by an approved community pass unless changes have been authorized by staff. On 10/28/2025, you were informed by halfway house staff that you were 2 weeks behind on substance. You proceeded to walk out of the staff office. This is a violation of your signed halfway house agreement. Specifically, I will save money and pay fees to the program as required. On 11/05/2025 at 6:15 p.m., you were issued a pass to go to St. Francis Hospital for medical treatment. Staff contacted the hospital to check your whereabouts. It was discovered that you left the hospital at 6:45 p.m. and returned at 12:36 a.m. for treatment. You were unaccountable in the community for approximately 4 hours. This is a violation of your signed halfway house agreement. Specifically, I will not leave the physical confines in a halfway house unless authorized by program staff or parole. I will only go to the locations indicated on an approved community pass unless changes have been authorized by staff. On 11/13/2025, Halfway House staff attempted to have another conversation with you regarding overdue subsistence and provide you with a payment plan. You refuse to sign the payment plan or pay subsistence. This is a violation of your signed Halfway House agreement. Specifically, I will save money and pay fees to the program as required. On 11/15/2025, you signed out of the Halfway House on a work pass at 7:33 a.m. and returned at 6:41 p.m. When staff called your employer to confirm your work hours on 11/20/2025, it was discovered that you did not report to work on this day. You were unaccountable in the community for 11 hours and 8 minutes. This is a violation of your signed Halfway House agreement. Specifically, I will not leave the physical confines of the Halfway House unless authorized by program staff or parole. I will only go to the locations indicated on an approved community pass unless changes have been authorized by staff. On 11/22/2025, you walked out of the Halfway House without authorization at 7:30 a.m. and returned at 6:24 p.m. You did not have permission from either Halfway House staff nor your parole officer to leave the house. You were unaccountable in the community for approximately 11 hours. This is a violation of your signed Halfway House agreement. Specifically, I will not leave the physical confines in the Halfway House unless authorized by program staff or parole. I will only go to the locations indicated by an approved community pass unless changes have been authorized by staff. On 11/24/2025, you walked out of the Halfway House at 12:04 p.m. without authorization. You did not return 12/04/2025. You were unaccountable in the community for 11 days. This is a violation of your signed Halfway House agreement. Specifically, I will not leave the physical confines in the Halfway House unless authorized by program staff or parole. I will only go to the locations indicated on an approved community pass unless changes have been authorized by staff. Charge number 5, no driving. On 01/11/2026, you were observed by Connecticut State Police troopers driving a white Nissan Maxima that was unregistered. You also don't have a valid driver's license. At no time did this parole officer give you permission to drive a motor vehicle. You were aware of this instruction based on your signed special parole additional conditions.
Okay, and can you please read the addendum that was submitted?
Sure. All right, the addendum I submitted, Mr. Smith was arrested by Troop C on 01/11/2026, Holland, and held on a $100,000 bond for the following charges. CGS 14-227A, operating under the influence of alcohol and or drugs, guilty, sentenced to 90 days jail, 05/11/2026. CGS 14-222 Astertic, reckless speed over 85 miles per hour. That was nollied on 05/11/2026. CGS 14-223B, double Astertic, engaging police in a pursuit, was nollied 05/11/2026. CGS 14-236, failure to drive in proper lane, was nollied 05/11/2026. CGS 14-147C, misuse of registration plate, was nollied 05/11/2026. CGS 14-213B, no insurance, was nollied 05/11/2026. CGS 21A-279A1 in parentheses, possession of a controlled substance, was nollied 05/11/2026. CGS 53A-64, reckless endangerment second, was nollied 05/11/2026. CGS 53A-167, interfering and resisting, guilty, sentenced to 90 days jail, 05/11/2026. CGS 21A-278BC1, illegal selling and manufacturing of cannabis over 8 ounces, was nollied 05/11/2026. Mr. Smith appeared in court at Rockville GA19 on 05/11/2026 under docket numbers T19R-CR26-0191161-S and T19R-MV26-0278696-S. BOPP may proceed with revocation. It appears on docket number T19R-MV26-028696-S. Mr. Smith owes a $500 fine.
Right, thank you very much. And the state is all the following exhibits that are pre-marked for identification as Exhibit A, signed statement of understanding, agreement, conditions of parole. B, arraignment, actual custody order. C, parole violation report, notice, and parole rights. D, parole violation report. E, police report, case ending in 11824, Connecticut State Police Troop C, Holland. F, BOPP rev hearing summary. G, BOPP decision information summary. H, local news article, WFSB. I, signed offender misconduct reports. J, offender incident reports from Watkinson Halfway House. K, residential disciplinary reports from Watkinson Halfway House. L, Community Solutions Inc. absconder report from Watkinson Halfway House. M, signed Halfway House agreement form. N, Community Solutions Adult Work Release Department of Corrections client handbook. And O is State of Connecticut District Branch criminal and motor vehicle printout. Did you receive notice of parole violation report, and those other documents I marked, and did you review them?
Yes.
Okay. And council's follow the following exhibit that is pre-marked for identification, Defense Exhibit 1, which is a list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
I do not. Could we make a correction? I didn't want to interrupt P.O. Davis there regarding the addendum. Everything he put on the record, I agree with. All the charges were nolly, but the one charge of operating under the influence, one charge of interfering. Just so the record is clear, there is no outstanding $500 that my client owns. That fine was remitted at the time of sentencing on May 11th of 2026. I'm not sure if P.O. Davis had access to that or not, but I just want to make sure the record, there is no outstanding $500 that Mr. Smith owes to the state of Connecticut.
All right, thank you. Okay, so at this time, I am going to do the oath so that both of you may speak. So Mr. Smith and P.O. Davis, can you please raise your right hand? You solemnly swear, solemnly affirm, as the case may be, that the evidence you shall give concerning this case to be the truth, whole truth, and nothing but the truth, so help you God, by penalty of perjury.
Yes.
Okay, so at this time, the state will have an opportunity. If you'd like to call witnesses, present evidence, and speak to any of the evidence submitted at this time, you may.
All right. This was a very serious case where Mr. Smith was charged with 10 criminal and motor vehicle violations. He was remanded on January 11th, 2026. I talked with troopers the night of the incident at length. Mr. Smith put hundreds of people, innocent people, at risk and in danger on the highway for really no apparent reason. It was self-reported by a family member to me that he was headed to the Patriots game. He did not have permission by me to drive, and he did not have permission by me to go out of state. The case made multiple news outlets, which is worth noting. I also want to say it should be noted that when I went to serve Mr. Smith at HCC, he took no accountability for his actions. He actually stated that it was the trooper's fault that put him in this incident. I don't think he's ready yet himself or the public for him to be out in the community. He was he was supervised by me for less than 1 month and committed these crimes. He also just received a disciplinary report for fighting on 7 days ago on 6/10/2026 at Carl Robinson.
We'll just speak to the charges currently. Any additional information, we can talk about the second part, but just regarding the charges at this time.
Okay. All right. And yeah, that's all I got. Thank you.
Thank you. We'll turn it over to council.
Yes. P.O. Davis, just a couple of quick questions.
Sure.
You said he was under your supervision for approximately a month. How many times did you actually meet with Mr. Smith during your period of supervision?
At the initial intake, and then I saw him once more, so twice in a 3 or 4 week period.
All right. Do you know who the parole officer at the time that was assigned to the halfway house was? Was it P.O. Stickles?
Yeah, I'm looking here. It looks like P.O. Stickles, but it looks like he was at Renaissance East in Waterbury. And if that was the case, it would have been Parole Officer Babbage.
Okay.
But Stickles has supervised him in the past, yes.
Okay. So regarding charge 1, charge 2, and charge 3, I think that was dealt with in court. I know the comments P.O. Davis just made, but my client did plead guilty to those charges. So he did take accountability for what occurred despite the comments that were made. Obviously, there's a guilty plea in court, and in order for that to happen, client needs to take accountability for that, which Mr. Smith did do that. Regarding the incidents at the halfway house, starting with the September 28th, 2025 incident where my client was in a waiting room and was told, was in the basement and was told to go into his room during visitation time. Mr. Davis, I'm sorry, can mix them up. Mr. Smith, do you recall what happened that day on that incident on September 28th of 2025?
Yes. So while I was in the basement, she told me to go to my room, and the basement is the workout area. So I didn't really, at the time, I didn't really understand why I had to go back to my room. So I went upstairs to the office and I asked, do you know why I have to go back to my room? Because they never told me to go back to my room from the weight room, working out room. So she was like, yeah, they're having visiting hours right now. So I'm like, okay, do you know when the visiting hours are over? She said, when they're over. And all right, no problem. And I went to my room. I never had no back and forth, or I never was rude, disrespectful to her, nothing. None of those words were said, nothing. So I don't know.
Okay. That's what your testimony, that's what occurred on that day.
Yes.
Correct. Okay. The incident on October 19th of 2025, when you were issued the pass to go to hospital, it looks like at 11:40 p.m. to St. Francis Hospital. Did you actually go to the hospital that day?
Yes, I actually went to the hospital.
Okay. And what occurred? Could you let the hearing examiner know what occurred while you were waiting to be seen?
I went to the hospital, and while I was sitting there, the lady told me that it might be a little while waiting. So I was sitting there probably about for like an hour or so. In the back of my head, I know I'm in the halfway house, so I know that I'm really on like a time management kind of thing. And the longest I'm out, the more worried they are or aware. So I went back up to her after that hour, and I asked the lady, do you know how long it's gonna take? She told me she doesn't know, she's not sure, because that same night, I don't know if you guys were aware, but there was 3 casualties that happened that night. So I don't know if the hospital was busy or what was going on. So I was just sitting there. So at the time kept going by, I was never admitted. No one ever came to see me. So I just left and I went back to the halfway house. When I got back to the halfway house, I informed that to staff, and they were like, okay, once Stickles comes in, you have to talk to Stickles. And when Stickles came in, me and Stickles had a conversation, and she told me that I was good. I was all set. There was no problem.
Right.
I didn't do anything wrong.
Okay. So from that hospital, you went back to the halfway house, they contacted Stickles, and you told her exactly what occurred, correct?
Yes.
Okay. The incident on October 28th regarding you not paying up the fees for the halfway house, do you recall the conversation you had with them, and did you admit to them that you were behind and you were willing to pay?
Yes, I did.
Okay. The next one occurs on November 5th, but where were you from October 30th to approximately November 5th?
October 30th to November 5th, I was in the hospital, and I was diagnosed with multiple sclerosis.
Okay. And you were at Middlesex Hospital first?
Yep.
And then were you at another hospital after that?
I went to Middlesex. They discharged me from Middlesex, and the staff at the halfway house picked me up. As soon as I got back to the halfway house, I threw up. I wasn't feeling good. I was dizzy, could barely walk, and a couple of the symptoms were coming back. So I was then transferred back Well, not back to Middlesex, but they transferred me to St. Francis.
Okay, so the incident that occurred on November 5th at 6:15 p.m., that was the same day you were released from Middlesex Hospital?
Yes.
Okay. And once again, on November 13th, the incident with the, they try to have a conversation with you regarding the money owed to rent. This one was after you were in the hospital and you were currently not working at the time. Is that a fair statement?
Yes.
Okay. Go ahead.
I wasn't, when I got out the hospital, I didn't work for about like 2 weeks.
All right, the incident on November 15th of 2025. I know you and I discussed this. Do you remember what day of the week November 15th was?
On a Saturday.
Okay, do you work on Saturdays?
I don't usually work on Saturday, but I picked up some extra hours on that Saturday.
Okay, and they claim, the halfway house is written, that you didn't go to work that day. They called your employer and you checked with the person you were working for and asked them if they ever called them. Is that a fair statement?
Yes, my boss said no one from the halfway house contacted them.
Okay, and did you let the halfway house staff know that your boss indicated they never called them?
I told them that, and it was like one in one ear and one out the other.
All right, the last two, November 22nd and November 24th, through our conversation, Mr. Smith, you did admit you did leave the halfway house because of the medical needs, but did you at any point in time discuss this with P.O. Stickles at the P.O. from the halfway house?
Yes.
Okay. All right. I don't have anything else to add regarding the first part of the hearing. As I indicated, I know the charges speak for themselves in court. My client did plead guilty to those charges. All the charges were nollied. I'm not minimizing what happened here, but from being in court for close to 20 years, G819 has a reputation of being a very hard court. Difficult court. And we can see from the sentence here, my client received 90 days on each count concurrent, and the remaining charges were nollied. So that's all I have for the first part of the hearing. I do want to be heard about his background at the appropriate time.
Thank you. Is there anything else further from the state before I make or announce my findings?
No.
No?
No.
Okay, so I'll be right with you with my findings. All right, so what I'm gonna do is I am going to announce my findings in regards to those charges. So regarding charge 1, I do find you violated conditional bail laws, obedience to the law, based on your conviction of operating under the influence and received a sentence of 90 days jail and interfering, resisting, and sentenced to 90 days jail. This is also based on exhibits A, D, E, and H. Regarding the charges of reckless speeding, engaging police in pursuit, and reckless endangerment. Second, I do make a finding on these charges. Although they were nollied, I do find the behaviors meet the elements of the charges. Regarding charges, failure to drive in proper lane, misuse of plates, and no insurance, no finding, as those are infractions. And I do not make a finding on the charges of possession of controlled substance and illegal sell, manufacture cannabis due to the behavior not meeting the elements. Regarding charge 2, obey all laws, drugs, and making no finding due to the charge not meeting the elements. Regarding charge 3, I find you violated additional condition, no consumption of alcoholic beverages. This is based on evidence provided in support of the charge, exhibits A and E, as well as the conviction for operating under the influence of alcohol. Regarding charge 4, I find you violated additional condition, halfway house placement, based on evidence provided in support of that charge, which exhibits A, M, N, I, J, K, and L. Regarding charge 5, I do find you violated additional condition, no driving, based on evidence provided in support of the charge, exhibits A and E. So that includes the fact-finding portion of this hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, council will have the same opportunity. This purpose part of the hearing is to help determine what outcome I will recommend. So at this time, P.O. Davis, would you like to say anything for the second part of the hearing?
Yeah, I'm very happy to hear that there was some accountability on Mr. Smith's part. I am aware of his medical issues. That's very unfortunate. The DR for fighting on 06/10/2026 is a bit concerning. That being only 7 days ago. And then the positive here that I have is he was working, and his residence where he lived with his sister seemed supportive, and his sister seems very supportive as well. That's all I have.
Thank you. I'll turn it over to council.
Yes, on behalf of Mr. Smith, and I appreciate you, P.O. Davis, putting that on the record. I understand, you were supervising him, but I did speak to him a few times. He just so the record is clear, he did take accountability for what happened. My client is only 25 years old. I'm not making excuses for him, but he's got a lot to learn. He's still young at the age of 25, in my opinion. He was born in Jamaica. He does receive family support from his mother, his brothers, and his sisters, some extended family. Upon his previous release, he was at the Community Solutions Halfway House program, the Watkinson House in Hartford. Then it looks like December of 2025, he was at the Connecticut Renaissance East in Waterbury. Then he was sponsored by his sister, as P.O. Davis indicated, until he was remanded. He did indicate to us back in 2022 he did successfully complete Open Earth Halfway House in Hartford. Then he was sponsored by his girlfriend, and then he was sponsored by one of his friends. He did obtain, looks like in 2023, his OSHA 30 certification through his job, J&L Precision Cleaning, and he obtained that certificate in Hartford. As far as his employment, it appears the last time he, J&L Precision Cleaning in Hartford is where he was working, and at a part-time job at People's Choice in Hartford for approximately a year. Also worked at Laser Ship in East Hartford. And while he was working there, once they ran his background, that employment terminated. But it seems to me, when he's out in the community, he's always had steady employment. He does receive medical care, is indicated because of his diagnosis of MS. Since he's been incarcerated, he did report to us he's employed as a chairman at Robinson, and he does receive his medical care at UConn Health. As P.O. Davis already indicated, he indicated to us is his sister. We provided you with an address and a phone number. He does want to enroll in trade school to study plumbing. And he does want to obtain his OSHA 60, which is the next level up from the 30. And he's indicated to us he can't return to his full-time J&L Precision Cleaning. Mr. Smith, anything you want to add about your background or what you heard that I commented on, what your parole officer commented on? Not about the charges, that has already been dealt with, but anything about your background and what you want to do when you get out. This is your opportunity to add to this.
I just want to, well, speaking on what P.O. Davis said about the fighting situation. I was actually assaulted, so it's not really like I'm here looking for trouble. I'm here trying to get my mind right, Look, I'm looking forward to get back to the real world and do what I have to do, become a better person. But really speaking on my behalf, I take full responsibility, accountability for my actions, and understand that what I did was wrong. I sincerely apologize and accepted the consequences of my decisions. Since being incarcerated again, I have reflected on my mistakes, and I am committed to making better choices. And moving forward in a positive and law-abiding way. And that's pretty much really what I have to say.
Thank you. I appreciate your statements. Is there anything else from either party?
I do not have anything else.
I do not have anything else.
Thank you. So I will be with you shortly, my recommendation. I do want to ask Mr. Smith, do you have a problem with alcohol or any type of illicit substances?
No, I don't. No.
If you are an alcoholic or were an alcoholic, you are an alcoholic today.
Right, so I have reviewed all the evidence that was submitted by the state as well as council, and I've listened to testimony today. There are some things that I am going to put on the record. You were in the community approximately 4.5 months before you were returned to custody, in which you received new serious. This was a serious incident, obviously, as was stated by your parole officer. It did put the community as well as yourself in severe danger. You received a new conviction for operating under the influence of alcohol as well as interfering, resisting, and there were findings made on other charges as well. You completed the sentence of the 90 days jail as of the 5/11/26. There are 2 prior criminal violations on this period of special parole supervision, which was noted. It is similar behavior to what you are in for now at this time. So there has been a pattern of the same type of dangerous behavior, which is a serious concern. As well as it appears you are non-compliant in the community since your release on 8/28/25 to the community that led up to this incident. Your officer recommended 12 to 18 months incarceration. I was happy to hear as well, your officer stated that there was some type of accountability because I believe that's important for you before you can move forward and hopefully change your behavior. So I do hope that you take and think about what you've done because it is extremely serious and a lot of people as well as yourself could have been killed in this incident. So based on the information that I have, I am going to recommend that your parole be revoked and that you be re-paroled for April 12th 2027, which is approximately 15-month period of incarceration. I recommend the following parole conditions: no consumption of alcoholic beverages, no contact with your co-defendant Cameron Mathis and Eli Jordan, mental health evaluation and treatment deemed necessary, those operation of motor vehicle. My findings are going to the parole board on July 2nd. So if the board wants to let you out sooner, they may. They can let you out anytime sooner. As of 7/2, they may let you out. That's the soonest date. Anytime in between, and just know that they can max out your special parole. You're on parole till March of 2029. So just know that that is an option. I hope that you think about your actions while you're in it before you come out and that you make better choices out there. So you will get this in writing what the board's decision is about a week after July 2nd. I believe you can also talk to your attorney.
May I have that date? It's April 17th of 27?
April 12th, April 12th of 27. Yeah, there was a year sanction on the last violation, so I believe that this amount is my recommendation.
All right,
So is there any questions, sir?
No, I just want to explain. Yuri, so it's going to the board on July 2nd. She indicated you and I will get something in writing. If they don't agree with this and they reject it, there's a possibility to be another hearing. I'll set up a legal call with you. Any questions after we get the report, you know how to get a hold of me and we can discuss it.
All right.
All right.
Do you
All
have
right.
any
Good luck
questions
to you.
at this moment?
No questions.
Okay, so you're all set, sir. Wish you the best of luck.
All right. Thank you.
Thank you, Pio.
Yeah, have a good day.
Thank you.
Thank you.
She recommends a 15-month sanction. That's what she recommends to the board. Now we're going to go and see what the board says. So they're going to say, wait, that doesn't seem too much. We should actually have a hearing. We should talk to this man. We should see what's going on here. You know, we can hold you until 2029. He did get in an incredibly dangerous police pursuit. He didn't follow 1 day of supervision from day 1 of getting out, and he could kill himself or other people. He's drinking. He says, even at the board, he says he doesn't have a drinking problem. Remember, he just spent years in prison and he can't. Okay, well, I'll calm down. I'm sure the board will correct this.
Good morning, I'm here examiner Meister, today July 2nd, 2026. Can the board members please state your names for the record?
Panel Member Barry.
Councilmember Rodriguez.
Deborah Smith Palmieri.
This is a final revocation due for Smith URE number 431159. I recommend a revoke and a referral date for April 12, 2027 with the following conditions. No consumption of alcoholic beverages, no contact with co-defendants Cameron Mathis, like Jordan, mental health evaluation, treatment deemed necessary, and operation of a motor vehicle. Does the board accept or reject this recommendation?
I just have a few corrections. There was a no victim stipulation originally that somehow got dropped. So I have 2 victims, JJ and NG. He's down for a robbery for 78 months, special parole for robbery first. Those are the victims, JJ and NG. And then the co-defendant's name, we have as Eli. I saw that it was Elijah, and Jordan with an E, not an A. I don't know if I did that. I don't know if I put the A. So I don't know if it says Jordan with an A, because I don't remember that. I wrote it as it was in the report. No, I'm saying, I don't, oh, I thought that I wrote it as an A. Okay, all right. Is there anything else? All right, are there any objections to the sanction? No, okay, so I move to accept the hearing examiner's recommendation, adding back the condition of no contact with the victims, JJ and NG, and no contact with the co-defendants, Cameron Mathis or Elijah Jordan. Is there a second?
Second.
All in favor?
Aye.
This includes my view for Smith URE number 431159.
No. And of course, they don't correct it. Remember what they could have done. They could have had what's called a supplemental hearing. They could have sat in front of him. They could have said, wait a minute, sir, you said you don't have a drinking problem, but you were caught drinking while driving in a police guys, I want to ask you this one thing. If you or I went into the state of Connecticut, no criminal record, no felonies, no prison, not on our second 30, and we were in a car with narcotics packaged to distribute, drinking, speeding in excess of 90 miles an hour in a police pursuit with our lights off, driving dangerously, flip our car and crash. Do you think the state of Connecticut would be as kind to me or you? I mean, maybe they would be. I really don't know. They're pretty nuts. But you know the funny thing? I wonder, even the things she found no findings on, it's like they go out of their way. They literally go out of their way to bend the truth, to bend reality, to make us not, to say, you're not seeing what you're seeing. There's nothing to see here. There's nothing dangerous here. There's nothing too bad here. They literally will like a magician try to. Did you even get it? They give them an attorney, which has to fight a PO officer, which the PO officer has a full-time job herding kittens, wearing a bulletproof vest, carrying a gun, and now they have to go up against an attorney that all the attorney does is and the attorney actually plants a seed. Did you catch it? The attorney said, I find objection to you saying that my client didn't take responsibility for his crimes, which he didn't. Remember, he blamed everybody else to the PO officer. That's what the PO officer said. He said, I take objection to it. By him accepting the plea that they offered, he took accountability. And then in the rebuttal, the PO officer says, I'm glad to see my client took accountability. And then the board interviewer says, I'm glad to see that you took accountability. It was all planted, but he didn't take any accountability. The agenda-driven DA no the charges, but one, and gave him 60 days or something. He can't even be. He's in a vehicle without insurance, without registration. drinking and driving, narcotics, possessing to distribute, a convicted felon, and he had just done it a few months ago or a year ago or whatever. Honestly, like, what? And then he sits here and says, I don't have a drinking problem? And not in a million years, I believe he's going to the Patriots game. That's what it's the family. Oh, yeah, they're going, yeah, sure, he was going to the Patriots game, sure. It's like, guys, you just really, this is the most. And then here's a funny thing: the state of Connecticut, they're trying very, very hard. They're in the process. It's going to pass soon, I believe, to pass legislation that anyone under the age of 26 will be considered a child. So if you had done a triple homicide, I'm not exaggerating, it could be a quadruple homicide, it could be a mass killing, and you were under the age of 26 and you were given 5, 6, 7, 8 life sentences, you, by Connecticut law, will have the legal right, the constitutional right to get a parole hearing, just as if you were under 18. And they're doing that because they're saying the brain science says that the brain isn't fully developed. So if you buy into that, now I believe that your brain is not full. I think that is a proven fact by now, by science, but how you react to that fact is up to the states. The state of Connecticut wants to say these poor bebes, they can't control themselves. They have no impulse control. Their brains aren't fully. It's not their fault. And if you believe that, then why are you releasing them over and over and over again into the streets so that they can continue to? You get it? You can't have it both ways. If you truly believe, and they're showing you that, then keep him in prison longer. It's his best interest. Let him grow out of it. Let him age out, because he is going to kill himself, or he's going to kill other people, or both at the same time, because you fools continue to let him out. He has zero impulse control. Zero. Can you imagine what it would take somebody to get in a car without a proper plate and without insurance when you are backing you could be held until March of 2029? Was it 3 years? At the time he did this, 4-ish years? You're willing to risk all of that? But not only that, then you have booze that you're drinking, and then you have pot that you're selling, but there's also just finding. And think about this too, how insane this is. It's all a freebie, and he realizes this. The reason he does it is that he has the calculation. He's figured it out. It's the cost of doing business. At the moment that he gets in the jail, it's eating away at his time that he needs to serve. The sentence that he gets, it's not additional. He owes that time. So what's the big deal? You know, people don't understand this, but like, it's the cost of doing business. Everyone has their own calculations. We might think, oh my God, the cost is too high. I don't want to spend a day in jail. I don't want to spend a couple of years in prison. That's insane. But that's the way we think. That's not the way he thinks. That's not the way many those in the system think. They just think it's the cost of doing business. What did I do? I quit my job and started my own company a bunch of years ago. It was my cost of doing business. It ended up not doing what I wanted it to do. I sold my house. I had to move into my parents' basement, and I wouldn't change a thing. It brought me experience and memories and all these great things. But for me, that was a cost of doing business. I tried something, I failed, I had the repercussions of it, and and I would do it again. It's my calculation. It's my cost for him, and all these the cost of doing business is okay. So you go to prison. What's the big deal? Yeah, well, I'm dealing. I'm getting the fast life. I got 3 months of partying without thinking. All right, so I spend 3 months in jail. I'll spend 9 months sanctioned. Anyways, it's a 2-for-1 freebie. I owe the time. I'd rather spend it in prison with my buddies than on special parole in a halfway house reporting to a PO. But they don't understand it. They don't see that. And it really is like, had he had he, you guys don't get it. You really don't. Had he, I'm not saying you. I know I'm preaching to the choir. I know I'm saying what you are thinking. I'm saying that like like those who are not who are not familiar with what's going on, I don't think really get it. Had he not had anything in his jacket, I'm pretty sure he would have served more time for this string of crimes than he got. And it's just the whole gimmick of the freebies and 2-for-1s and the this and the that's. And it really is disturbing. Like I told, I had a friend, I've said this story before. I had a friend who was 18 years old. He had 3 17-year-old passengers. He never did a drug or drink. And he was in his Camaro. It was big old Camaros. I forget. I think it was an 1980s 80 Camaro or something. And he was driving, and he was speeding, and the cops started chasing him. It was like an upstate, no traffic, no people. It was like a middle of nowhere, like Bumbleville type of place. And the buddies in the back peer pressure, go, go, go. So he went. He wrapped his car around the pole within the first mile. The judge there, he spent a couple of years in prison. He had nothing in his record. He was a good kid. And that was wrong. I think whatever the judge did there was really, really wrong. I think it was an injustice. Messed him up. But you have these extremes. Just insanity. Anyways, what can I do? I don't know. I just had to vent. I had to get that off my chest. It's really crazy. It really is.